Hi and welcome back. So today we will look at judicial notice and facts which the courts don't need any proof. They will accept them or take judicial notice of them. Now, Section 59 of the Evidence Act of Kenya says no fact of which the court shall take judicial notice need be proved. Followed by Section 60, subsection 1. It outlines all the instances where the courts will take judicial notice of a fact, and they include: number 1, all written laws and all laws, rules, and principles, written or unwritten, having the force of law, whether in force or having such force as aforesaid before, at or after the commencement of this act, in any part of Kenya. So all laws, acts of parliament, or all rules, whether written or unwritten, as long as they operate in Kenya and are at force or are active or have been passed, okay, they become, the courts do not require any proof of them, okay? Excuse me. Now, the second thing is the general course of proceedings and privileges of Parliament, but not the transactions in their journals. Okay, so Parliament proceedings and privileges. All right. The third is articles of war for the armed forces. Uh, the fourth is deleted by is deleted. So we go to the fifth, the public seal of Kenya, the seals of all the courts of Kenya, and all seals which any person is authorized by any written law to use. So all public seals, the courts accept them or take judicial notice of them. So the accession to office, names, titles, functions, and signatures of public officers, if the fact of the appointment is notified in the Gazette. Remember when we talked of presumptions in the last video, we said that one of the things the courts presume without requiring proof, presumed to be a fact, a proven truth, unless it can be disproved, is is the Kenya Gazette. If you recall, in the last video we talked about presumptions in detail and we discussed the instances. So in the same breath, under judicial notice, the courts take judicial notice of the content of the Kenya Gazette. If it involves officers who have been appointed, their names, their functions, and their signatures. Moving on, another fact is the existence, title, and national flag of every state and sovereign recognized by the government. So any flag of any nation in the world recognized by Kenya, that's a fact that the courts will take judicial notice of. The natural and artificial divisions of time and geographical divisions of the world and public holidays. So so time is universal. There is time, and if it's 2 a.m. in the morning, it's 2 a.m. in the morning. And if it's a Tuesday, it's a Tuesday. If it's a Monday, it's a Monday. It can, you don't need to prove that today, for example, is Sunday. All right, so public holidays, we have an upcoming holiday. It's not upcoming, it's actually today. So so those things are facts which the courts take judicial notice of, and they don't need to be proved. So moving on, the extent of territories comprised in the Commonwealth. So all states have territories, that are marked by boundaries. So all the territories in the Commonwealth countries, including England, I think Australia, if I'm not wrong, but I'm not sure. So moving on, commencement, continuous, and termination of hostilities between Kenya and any other state or body of persons. So uh, where a fact lies that there is hostility between Kenya and any other country, the court will take that fact on judicial notice, and it doesn't require to be proved. Where the hostility has ceased, it will also take judicial notice of that fact. The names of the members and officers of the court and of their deputies, subordinate officers and assistants, and of all officers acting in execution of its process, and also of all advocates and other persons authorized by law to appear or act before it. So the names of the members, judges, officers of the court, the bailiff, the clerks, everyone. Okay, their subordinates, assistants, all of them. Okay, including the advocates. Those are facts which the court will take judicial notice of, and they don't require to be proved. The rule of the road on land or at sea or in the air. So the rule of the law, Jesus, the rule of the road, meaning like you keep left, they keep left unless you're overtaking, something like that. So those rules on land, either in Kenya, in Kenya, on land, that is on the road, or at sea, or in the air. I don't know the rules there, but you get the point. So another instance is the ordinary course of nature. Like, for example, aging. Someone has aged maybe from, okay, not age, because if we go to age, then we need to prove that someone is a certain age. Okay, what can I say? The ordinary course of nature, like rainfall. I don't know really what they mean here, but let's just move on. The meaning of English words. Yeah, interpretation of English words. No, the meaning of English words. Like, a table is a table. Yeah, you don't need to prove the word table means table. So all matters of general or local notoriety. Okay. All other matters of which it is directed by any written law to take judicial notice. Now, if the court is called upon by any person to take judicial notice of any fact, it may refuse to do so unless and until such person produces any such book or document as it's considered necessary to enable it to do so. Okay, let's just move on. So it is a general rule that every party in a case at court must prove their facts. Whoever alleges must prove. So that is the general practice, okay? However, we have seen that certain things do not require to be proved, and we tackled that. One of them was presumptions, and today we are tackling facts which the courts will take judicial notice of. So, So the doctrine of judicial notice is considered a great exception to the modern rule that a tribunal of fact must, in coming to a decision, rely on facts that are proved. So it's a judicial notice is like an exception to the general rule that every fact must be proved, okay, in a court of law. According to Professor Thayer, this is James Bradley Thayer, a Weld Professor of Law at Harvard University in the 19th century. So he defined judicial notice is one of the oldest doctrines of the common law and is traceable to two ancient maxims: manifesta non indigent probation, that which is known need not be proved, okay? And another maxim is non referat quid notum sit judici, si notum non sit in forma judici. It matters not what is known to a judge if it is not known in judicial form. So the former, according to Thayer, existed so far back that it may be coeval with legal procedure itself. So that which is known need not be proved. That is the maxim on which judicial notice is built. So the doctrine of judicial notice allows a court to find that a fact exists without calling evidence to prove it. In its most notorious form, it refers to notice taken of facts which are so well known as to render proof unnecessary. So we all know all across the world that when somebody mentions the word weekend, it refers to Saturday and Sunday, the 2 days of the week, okay? So if it is well known, it's unnecessary to prove that, okay? Okay, so it refers to facts which a judge can be called upon to receive and to act upon, either from his general knowledge of them or from inquiries to be made by himself from his own information. So judicial notice can be summarized as covering two types of facts, okay? Number one, matters of such common knowledge that they are really contentious, like the one I mentioned, that water means water. It's an English word which means water, and you don't need to prove, okay, that fact. These cover broad classes of indisputable scientific, medical, cultural, and historical facts, including the laws of physical nature, well-known social habits and usages, laws of physical nature like the Newton's law of for every action there's an equal and opposite reaction, there's gravity, that things will always fall to the ground and not float in the air, such things. So well-known social habits and usages and notorious historical events such as world wars, world wars and what? Tsunamis, I don't know. So number two, like coronavirus is a notorious event which will be in the history for future generations, okay? So the second type of facts is matters the court may be assumed to know already by virtue of its stature and expertise, such as the validity of legislation put before it. So there are two categories. One is facts which are known universally in history, medical terms, physical laws of nature, all those things, days of the week and other things. Then we have another category which is more technical. Things like laws. That was the first thing we said under Section 60 of the Evidence Act of Kenya. One thing that was number one, top of the list, as a fact which courts take judicial notice, is all laws or rules, whether written or unwritten, as long as they are active and apply in Kenya that the court will take judicial notice of. And if you remember, if you watched my last video on presumptions, I also mentioned laws or acts of parliament as presumptions, okay, that the court will presume to be true unless, okay, that is irrebuttable if I remember correctly. So we move on. All right. Judicial notice is provided for, of course, the sections we mentioned previously in our introduction, sections 59 and 60 of the Evidence Act of Kenya, Cap 80. The sections are intended to reflect and simplify the common law. Each section covers a range of facts which we mentioned, so there's no need to repeat them. So why judicial notice? The principal purpose served by judicial notice is to promote judicial efficiency by avoiding the expenditure of time and effort involved in producing unnecessary evidence. So imagine if every court required that you prove water is really water, or the word water, English word means water, and somebody had to go like to the origin of the word, to the first person who came up with the word and the construction of each letter. It will just waste the court's time and the efforts. Okay, now in effect, judicial notice bears the expense of proof. Not only is the proponent of the judicially noticed fact relieved of the burden of presenting evidence, but also once judicial notice has been taken, the party against whom the notice fact operates is, at least under the traditional view in civil cases, prohibited from challenging the veracity of that fact. So the one on whom the fact that has been judicially noticed operates cannot prove on the contrary, okay? Cannot challenge it, cannot challenge that fact. You cannot challenge that, things fall to the ground and they don't float, okay? They don't float, they fall. You can't challenge that. You can't challenge that Saturday is not the Saturday we all know. Okay, judicial notice may be discretionary or mandatory. So there are two now types of judicial notice. We have discretionary, where it's up to the court to decide whether they will take a fact on judicial notice, or it can be a must for a court to take a fact on judicial notice. If it is discretionary, then the court may, in terms of subsection 3, choose to take judicial notice of the fact, or may reject the request and require the production of evidence. If it is mandatory, then in terms of subsection 1, the court must take judicial notice. All right, this is just what I said. So it is also agreeable that the effect of the court taking judicial notice is different in civil and criminal. So you see, we are breaking down slowly by slowly. We started with saying there are two types of facts which are taken on judicial notice. We say there are common knowledge facts and natural or cause of nature facts. Then we have matters of technicality like legislation and laws. Then we moved on and subdivided and and further categorized it into discretionary, judicial notice, and mandatory, where the court has an option in one instance, and in another they have no option but to take judicial notice of a matter. Then now we are moving to say that there can be a civil judicial notice and a criminal judicial notice, because there's like a distinction in both civil and in civil from criminal. Okay, now in a civil trial, the fact taken notice of is thereby conclusively proved. Okay, In a criminal case, due to the higher standard of proof, the accused person has the right to contest every fact that might tend to incriminate him. Therefore, the court taking judicial notice would simply make the finding that it took notice of, but would not require this outcome and would not prevent the defense from presenting evidence to rebut the noticed fact. So just like I thought earlier that it is indeed true that in civil matters, whereas in civil matters, any fact that the court takes judicial notice of is conclusive and no one is allowed to challenge it. But in criminal, because of course we have discussed in the videos I made previously on burden of proof, we saw that in civil and criminal, the burden of proof is different. In civil, is on a balance of probabilities and is lighter to discharge, whereas in criminal, it is heavier beyond a reasonable doubt. And so the prosecution is required to do everything it needs to do to discharge that burden. Okay. Because of the nature of criminal matters, it stands to reason that an accused person can indeed challenge a fact that the court has taken judicial notice of. Okay, if the accused person can present evidence to rebut the noticed fact, then the court will allow that. Now, the United States Supreme Court has suggested that due process may be violated when judicial notice is taken of a fact and the party against whom the fact operates is not given an opportunity to challenge it. Yeah, so that is in the case of Ohio Bell Telecommunication Company versus Public Utilities. All right, that was a US case which now explained or pointed to the fact that there can be some unfairness, okay, if a matter that proceeds on judicial notice without giving the party on whom it operates a chance to rebut it. Now, in a case where the plaintiff having been bitten by a camel while feeding it in a zoo run by the defendant, the question arose whether a camel was a wild or domestic animal. Yeah. Books about camels were consulted and expert witnesses gave conflicting evidence on oath concerning the behavior of camels. The trial judge resorted to the doctrine of judicial notice and held that camels are domestic animals. We all know, it's common knowledge that camels are domesticated. They cannot, I've never seen a camel where I am from live in the grasslands, with the zebras and the lions. So to me, they are more like a cow, for example, or a goat that you keep and you feed and you get milk from. So it's common knowledge. So the trial judge resorted to the doctrine of judicial notice and held that camels are domestic, not wild animals. The Court of Appeal affirmed the decision when it was observed by Lord Colson. The reason why evidence was given, he said this, the reason why evidence was given was for assistance of the judge in forming his view as to what the ordinary course of nature in this regard, in fact, is a matter of which he is supposed to have complete knowledge. So judicial notice is a court's personal recognition of generally known facts without the necessity of proof. In everyday life, courts accept everyday truths without necessarily proving them in evidence. That is self-evident facts, which it is acceptable to take for granted. Recognition of facts without formal proof is a matter of expediency, and no one has ever questioned the need and wisdom of accepting the existence of matters which are unquestionably within public knowledge. Yeah, so that's basically what we have been saying. Where in this case, it's a very nice case, and it falls, if you can test your understanding of the two types of facts we discussed, it falls under the first category of facts, which were facts which are common knowledge or physical laws of physical nature, things like that, things that everybody knows. So who is a camel? Is a camel domesticated animal or a wild animal? That is a common, it falls under the category of facts which are common knowledge. Yeah, so it didn't require for the courts to start research on this. I think the research they did here of books and consulting expert was unnecessary to me, but as Lord Colson observed here, that it was just to affirm. The trial judge was simply just affirming his view, okay, of the fact that a camel is a domestic animal. It doesn't have to take caution, but it is unnecessary according to me. Okay, shutting the judicial eye to the existence of such facts and matters is in a sense an insult to common sense and would tend to reduce the judicial process to a meaningless and wasteful trial. Yeah, that's true. So the court cannot separate itself from common knowledge that everybody knows outside here in life. They cannot suddenly want to act like some robot that doesn't understand the rules of nature, the laws of nature, the fact that the rain falls, maybe rain in the desert is very little or negligible, and in rainforest it's, all those things. It can't just be this blind, disconnected entity. It has to be alive and respond to what's going on and what people know. Mm. So we mentioned one rationale or purpose of judicial notice, why it exists, for what reasons does it exist, excuse me. And we said it is just for efficiency, avoiding unnecessary expenditure. That is one reason, avoiding wasting time of the court. That is another reason. Another reason is where there's possibility of evidence getting more complicated. So it's just to avoid complications, to avoid confusion, diversion, and other challenges related to digging deeper and deeper for evidence. The fact is judicially noticed, need for proof is obviated, and time is saved. So time saving, effort saving, it's just making the journey towards getting justice more expedient. Yeah, so those are the reasons why it exists. So the only con of judicial notice is the fact that it denies the party on whom that notice operates the opportunity to contest or challenge it. But we saw that in criminal matters that is allowed. So I don't see why that is a con, maybe only in civil cases. So here there's an American case example showing the disadvantage of using judicial notice. So in an American case where a worker claimed workmen compensation benefits having fallen from a height, his claim was denied by the Office of Workers' Compensation. At hearing, the presiding officer said that it was her experience that a soft tissue injury heals in 6 weeks and took judicial notice of that fact, thus preventing the complainant from contesting that proposition and disallowing his claim. The decision was reversed on appeal on grounds that it was an error of law for the presiding officer to take judicial notice of such intricate medical knowledge. So in the end, it wasn't even a con because it was remedied on appeal. Okay. Uh, so we said before that uh, judicial notice can either be discretionary, where it's up to the judge to decide whether he or she will take a fact on judicial notice or not, or it can be mandatory and there's no way out for them to decide except they have to do it. So we also have here a point to note that when a court has to take judicial notice of any fact, it can do so either by the motion of a party. So where does it all begin? How does it start? It can either start by on the initiative of a party to the proceedings, or on the court can do it on its own motion. All right. When this happens, it is not an opportunity for the judge to apply its own personal knowledge, save that he may only apply such knowledge to evaluate the evidence before him. In this regard, it has been held that a court acted improperly when the justices made use of their local knowledge of tidal conditions. So you can see here that where a court moves on its own to take judicial notice, some errors can occur because a judge is discouraged from using their own personal knowledge on things, on the weather, or on lakes, or the sea, or the tides, or the moon, or the sun, to arrive at decisions. Okay, they can. Someone's personal knowledge on a matter can be limited, and where such matters fall maybe under the ambit of medicine, under the ambit of some technical things that require study or expertise, then it's best to leave it to the expert. Okay. um, So the list of facts mentioned in section 60, which we say the instances or the facts which the court takes judicial notice of, is not exhaustive. So the list can grow, and indeed the purpose of the section is to provide that the court shall take judicial notice of certain facts rather than exhaust the category of facts. So the section we mentioned, section 60 of the Evidence Act of Kenya, Cap 80, is not conclusive, exhaustive. It just mentions most of them, but there's room for others. Okay, so now it just goes to explain in detail all the things under section 60 which we just briefly mentioned. Let us just pass through them. So the first thing we mentioned under section 60 was all written laws and rules, whether written, unwritten, whether before the commencement of the Evidence Act or after or during, those the court will take judicial notice of, and it will not ask for proof. So we saw parties do not need formally to prove that such laws exist. So when you go before a Kenyan court and you are maybe quoting a section of the Community Land Act, you don't need to prove that such a law exists because it exists. So, or you don't need to start proving that the due process was followed in passing the Community Land Act into law, the Community Land Bill into law, and that it was the due process was followed and everything was regular. You don't need to do that. So evidence is not required to prove contents of acts of parliament or that they have been duly passed by parliament. All forms of delegated legislation and conditional legislation also amount to law. Okay. All orders and notifications made and issued under statutory powers and which are legislative in nature amount to law. So here they're just explaining what amounts to law and what doesn't. So a statutory order or notification will be legislative in nature if it adds or amends a section of an act of parliament. Okay. So this, please keep in mind that the court will take judicial notice of all laws of Kenya, okay, not of foreign jurisdictions, okay. Now, Section 48 of Evidence Act permits proof being tendered and opinion of experts being adduced in evidence in proof of a point of foreign law. So where we are discussing a foreign legislation or a foreign act, the Section 48 of the Evidence Act requires or permits proof. Okay. Yeah. Under Order 2, Rule 3 of the Code of Civil Procedure, every pleading shall contain a statement in concise form of the material facts relied on by a party, but not the evidence nor the law of which a court may take judicial notice. But the rule against pleading law is restricted to that law only of which a court is bound to take judicial notice. As the court does not take judicial notice of foreign law, it should be pleaded like any other fact if a party wants to rely on the same. So if a party wants to rely on the law, let's say of what can I say, of the law of Tunisia, for example, okay, they will have to plead it. All right, but of course the general rule is that you don't plead law, you plead facts. So when you are constructing your plaint, you don't start saying under section this, the plaintiff claims under section this, and his right to this was violated. No, you just state the facts. But that only applies to the Kenyan system, the Kenyan laws. But when you want to rely on a foreign piece of legislation, then you have to plead it. You have to indicate section this of this, and you say what the section says. So let's move on. Courts will not take judicial notice of foreign law, which in any case must be proved, and the burden is on the party wishing to rely on it. In terms of Section 48, foreign law is a question of facts calling for expert evidence and cannot be taken judicial notice of. So we have several cases here in Guaranteed Trust Company of New York versus Haney and Company. It was held that foreign law is a question of fact to an English court, the opinion of an expert on the fact to be treated with respect, but not necessarily conclusive. In BT versus BT, it was held that the American law in English courts must be proved by the evidence of experts in that law. In Lazard Brothers and Company versus Midland Bank Limited, their lordships of Privy Council observed that what the Russian Soviet law is a question of facts of which the English court cannot take judicial cognizance, even though the foreign law has already been proved before it in another case. So even if in a previous case there's a precedent that showing that somebody relied on it as a fact, relied on a foreign piece of legislation and pleaded it, the court, the party that wants to rely on it in subsequent cases cannot draw on the as a precedent on previous cases. Yeah, the court must act upon the evidence before it in that actual case. So it's every case. The court must act upon the evidence before it in that actual case. So in Halsbury Laws of England, what it says is that the English courts cannot take judicial notice of foreign law, and foreign laws are usually matters of evidence requiring proof as to questions of fact, whether that section in that act exists. There is thus no doubt that in the courts in England and India, a point of foreign law is a matter of fact and should be pleaded as such. All right. Unwritten law includes customary practices. We say that our point under section 60, subsection 1, we say all laws and principles or rules, whether written or unwritten. So here we are defining what we mean by unwritten law. So it means customary practices on which it is well settled that if the courts have recognized the custom in a particular matter for a long time, that is considered to be the law and it is not necessary to prove it. So it's not necessary to prove it. Customary practices or customary law is what is meant by unwritten law. Now, the courts can take judicial notice of such a custom. The aforesaid view is fortified by the Supreme Court of India in the case of Ujagar Singh versus MST Geo. The following observations of that court may be read with advantage. All right, at page this. Let's just read through it. It therefore appears to us that the ordinary rule is that all customs, general or otherwise, have to be proved. Under section 57, which is of the India Evidence Act, which is section 59 of the Kenya Evidence Act, however, nothing need be proved of which courts can take judicial notice. Therefore, it is said that if there is a custom of which the courts can take judicial notice, it need not be proved. Now, the circumstances in which the courts can take judicial notice of a custom was stated by Lord Dunedin in Raja Rama Rao versus Raja of Pitapur. That is a case of 1918. Now, in the following words, when he said, when a custom or usage, whether in regard to a tenure or a contract or a family right, is repeatedly brought to the notice of the courts of a country, the courts may hold that custom or usage to be introduced into the law without necessity of proof in each individual case. All right. Yeah. So, um, oh, okay. Okay, so remember when I said that customary laws, so there's something. Customary laws, customs, general customs known to our community or the society. So customary law can be taken judicial notice of, but it's not all customary law. Like a part of it can be taken judicial notice, another by judicial precedent, where in previous cases it was held that this is the test, for example, for presuming marriage in Kenya after this period of time has elapsed, after issues have been born or things like that. So where they have been cases or jurisprudence that actually grows and establishes that a customary law or a practice. Yeah, or through evidence. So also we can have instances where customary law is proven by way of evidence and witnesses, like in the case of Angu versus Atta, that is a 1916 case, a West African case, okay, where the Privy Council said the following: as is the case with all customary law, it has to be proved in the first instance by calling witnesses who are familiar or who are experts of the native customs, like the elders in African customary law, the Council of Elders, So until the particular customs have have been frequently proven in court as to become jurisprudence or precedent, where now the courts can take judicial notice of them. So there's like a hierarchy. First established in the first instance through evidence, then in other more and more previous cases, so the subsequent cases, the jurisprudence on that particular matter will be growing and developing until it becomes a matter to be taken judicial notice of. Now, the Court of Appeal, in the case of Kimani versus Gikanga, that is the case of 1965, where the issue arose as to whether in a dispute involving customary law, whether customary law should be taken judicial notice of. Now, this is a case close to home because it's a Kenyan case. Judges were of the opinion that the party that seeks to rely on the customary should prove that customary law as a matter of fact by calling expert witnesses. This is because of the difficulty of establishing what the customary law is at any given time, since it is not written. All right. So in this case, it was stated by a majority judgment that because of the lack of authoritative textbooks on customary law, and also because of the lack of case law on customary law, it is necessary that a party relying on African customary law will have to call evidence to prove the African customary law as he would prove any other relevant fact in his case. So, excuse me. So what is the current position? I would say The current position seems to be is that where customary law on a certain matter has been common knowledge or has been uh, accepted as a fact, okay, as true in the practice of the court, then that matter will be taken judicial notice of, unless the contrary is proven. Okay, so yeah, so it is arguable. So unless that customary law is well known by everybody and well documented, because uh, I think there are books on customary law in Kenya by Eugene. So some of these laws have been documented, like where in a case of Kikuyu, a presumption of marriage, in the case of Kikuyu customary marriage, they require the slaughtering of a ram. So such things, those are steps that are necessary to be done and cannot and have been documented by Eugene in her works. So it shows that it is notorious. First, it is well documented. Second, the whole community of Kikuyu people in Kenya, who are the majority tribe, know this fact, so it is notorious and at the same time well documented. So such facts will be taken judicial notice of, but where customary law is not well documented, okay, judicial notice will not be taken. So we have a case here, an example. In a case involving customary law where the dispute was between a cosmopolitan Luoman's widow and his clan members, judicial notice was not taken, and instead expert evidence was called to prove that low customary law required burial of a deceased man in his ancestral home. Okay, that is the case of Virginia Edith Wambui versus Josh Ochieng Ougo and Omolo Siranga. It's a 1982 to 1988. It's a 19, yeah. Oh, this is the famous SM Otieno case where it was held that the common law of Kenya is the African customary law. All right, so it's not the English common law, it's the African customary law. Now, this is a very famous case. The main issue of contention was the burial of the deceased husband of a wife who didn't belong to the same clan or tribe. So now it was, in this case, the courts did not take judicial notice of this custom of burial, okay, in the Luo community. It required expert evidence on the same, which was submitted. Now, the position has been distinguished where the court without inquiry took judicial notice of the fact that most of Kenya's African communities were patrilineal, and under their customs the matrilineal home belonged to the husband. Therefore, upon divorce, it was usual for the wife to leave the home and take away only her self-acquired personal property. This was the case of Kivuitu versus Kivuitu, but I will have you know that this case was overruled by other cases. So we have the Matrimonial Property Act right now, which is the deciding authority. on what happens to the matrimonial home, all right, upon divorce and upon the death of one of the spouses. Customary law is unwritten law which courts can prima facie take judicial notice of. However, in practice, courts will usually require customary law to be proven by way of evidence unless it is well known. So that is the position. There's no need to keep on repeating the same. So there's a comparison here with South African jurisprudence. Now, in the Republic of South Africa, the court has emphasized that Section 1, Subsection 1 of the South African Evidence Amendment Act of 1988 provides that any court may take judicial notice of the law of a foreign state, insofar as such law can be ascertained readily with sufficient certainty. It has more or less been accepted that customary law is the equivalent of foreign law and had to be proved by expert evidence. Since 1988, the question whether judicial notice may be taken of indigenous law has been simplified in that a court could take judicial notice of it so far as such law could be ascertained readily and with sufficient certainty. The question of proof will only arise when the law is not readily ascertainable and with sufficient certainty. The South African courts, obviously, as a point of reference, take judicial notice of statutory customary law. They will, for instance, take judicial notice of the Recognition of Customary Marriages Act of 1998. Okay, so the South, unlike in Kenya, the South Africa does not, South African courts do not take judicial notice of customary law unless it is in a statute form. Like the example, Recognition of Customary Marriages Act of 1988. So I would say they really prioritize codification or writing down of customary laws, okay, for them to be authentic laws or applicable laws. And in Kenya, we saw the situation currently is that where customary law is well known or well documented in a textbook like the one by Eugene and others, then it is taken judicial notice of. Where it is not, evidence is required. Also, in comparison, it is the Kenyan case that any foreign law has to be proved by way of evidence and has to be pleaded, all right, as a fact, all right. Whereas in South Africa, if the foreign law can be ascertained and it can be certain that it is indeed the law of England or the law of America, or I don't know, the law of India, then it passes without requiring evidence. And yeah, so that's so that is the case of South Africa vis-a-vis Kenya. All right, so in South Africa, it needs to be codified or written. Okay, so now that is it. That's all there is for, and it was the longest, to be honest. I even forgot where we were. So that's it for the first fact, which the court will take judicial notice of under Section 60 of the Kenya Evidence Act, which is all written laws, rules, written or unwritten, all right, will be taken judicial notice of. Now, the other one is the general course of proceedings and privileges of Parliament, but not the transactions in their journals. So, courts take judicial notice of the general course of proceedings in Parliament. So, that courts will, for example, take judicial notice of the fact that a bill ought to be read again after 6 months. And also, since in practice all that is discussed in parliamentary proceedings is privileged information, civil or criminal cannot be brought against legislators for what they say in parliament. So you cannot just go to the Hansard, which is the document or the journal of parliamentary proceedings, and then on discussions, then you say you bring about criminal or civil action against legislators for what they have commented during the discussions. Yeah. So another one is articles of war for the armed forces. Courts are to take judicial notice of documents and writings on war due to their sensitivity and confidentiality, and no evidence is required to prove them. So no evidence is required to prove them. It has been held that the classification secret appearing on a document originating from a government office was a matter of public record of which the House of Lords was entitled to take judicial notice of. So where something has a stamp which says confidential or secret, it will be taken judicial notice of. Where the question was whether an applicant for a writ of habeas corpus was an enemy alien, the Court of Appeal took judicial notice that the country was still at war with Germany by accepting as conclusive a certificate from the Foreign Secretary to this effect. That was a case of Republic versus Botril ex parte Meister, 1947. That's when Germany was at war with England. Yeah, so we move on. Now, another instance is the public seal of Kenya, the seals of all the courts of Kenya, and all seals which any person is authorized by any written law to use. Now, sovereignty of nations ordains that all nations recognize each other. That their respective populations, external relations, symbols like flags and seals. Okay, so any document that shows the public seal of a country, okay, will be taken judicial notice of. Okay, the flag of a country. But the government has to have been recognized. Okay, so the foreign government whose seal or flag is being relied on has to be recognized by Kenya for it to be taken judicial notice of. Okay, so we move on to another instance, the accession to office names and titles, functions and signatures of public officers. If the appointment is notified in the Kenya Gazette, this section recognizes the authenticating function of the government gazette, so that once an act is gazetted, it is needless to prove such when it is in issue. The fact that any appointment, name, title, function, or signature has been gazetted means that it becomes unnecessary to call for evidence of such appointment, and judicial notice must be taken of the same. So where public officers are appointed, the appointment includes, the process includes putting up a notice informing the public of the name and the position of that person that he will be holding. So such things are taken judicial notice of by the courts. and do not require to be proved. Okay, we move on to the existence, title, and national flag of every state and sovereign. I think recognized by the government. I think this is what we said when it's the same, like in the public seal, the same here. The Kenya has to recognize that country. Okay, first. So in order for this, for the courts to take judicial notice of the of the flag of a country or state, that country must be what do you call, must be sovereign. It must be independent sovereign state. Okay. Mm. Now, moving on, natural and artificial divisions of time and geographical divisions of the world and public holidays, like today. So, where it is believed that time manifests at a certain point in the course of the day or night, such as midday to be 12 p.m., midnight to be 12 a.m., morning to be a.m., or evening p.m., you can't argue over such things. Okay. Also, another thing is geographical boundaries, which separates countries or states in a region. Uh, mm, Public holidays, like today. Okay. So we have an example here of time that was taken as judicial note. It was taken on judicial notice. So in a robbery case, a robbery with violence case, where the fact in issue was visibility, okay, during identification of the robber, the appellants argued that 5:30 a.m. was too early in the morning for them to have been properly identified. The court took judicial notice that in the month of February and March, the sun rises very early in the Nanyuki region of Kenya, and it was possible for the appellants to be identified. Still, on matters time, judicial notice has been taken of the fact that in Nairobi, the state of natural lighting at 6:30 a.m. would be good and would not impair visibility. Yeah, is that true? That was the case of Bishar Abdi versus Republic 2008. Yeah, 49. And the case of the robbery with violence was the case of Ahmed Dima, Hooker, and others versus Republic of 2003. So in both these cases, we saw that judicial notice of time was taken by the court. In another case where a party applied to court to compel the attendance of a witness who at that time was in Switzerland, the court took judicial notice of the fact that Switzerland was in Europe, and as the proceedings were taking place in Kampala, it would be excessively expensive to bring in a witness from Switzerland to Kampala. Remind me. Oh yeah, we were discussing in a video this question in the previous video I did on hearsay, and I said that an exemption to hearsay would be admissible where someone could not be procured. their attendance could not be procured except by a very high expense on the courts and wasting the court's time and everything. So that was on hearsay. Yeah, I really like to make these connections because if you cannot connect as you read through a book, it becomes very hard to remember these things. So it's good to make the necessary connection whenever you see some similar points coming up. Mhm. So that's also the case of hearsay here. It's about judicial notice. So the courts have also had to take judicial notice of the vastness in distance between Nairobi and The Hague, accepting that it would be unreasonable to bring a witness from there to testify in Nairobi. Yeah. Hague, I think, is in Netherlands, if I'm not right. If I'm not wrong. Courts have also taken judicial notice of the remoteness, absence of a reliable regular transport system, extremely poor road network, and harshness of the environment generally in Mandera County of Kenya, where the issue was on geographical zoning of cities according to the predominant occupation of occupants. The court took judicial notice of the fact that Mission Street in San Francisco is in a business district. So you can see it's not cut and dry. Like there are no specific situations where the court can take judicial notice. This, like we saw, can be discretionary on the part of the court if they, while applying their general knowledge of a matter, they are able to take judicial notice of things generally all across. We saw even when it comes to availability of witnesses, when procuring them is difficult, the distance, okay, between places, the fact that it's expensive to avail witnesses when the distance is very huge and different continents, all these things, whether a street or belonged in a business district or not, yeah, whether roads in a particular county are inaccessible or not. So all these things, a judicial notice is huge, it's wide, it's not, the list is not exhaustive, like we say. So it's very flexible and wide. That's just what you should know. And there's the discretionary element in it. Yeah. So on the matter of public holidays, judicial notice has been taken of the fact that a certain day of the month was a Sunday according to the Julian calendar. So that was in the case of Hawthorne versus Shackleton. It's an 1835 case. In Nigeria, an issue was whether there was sufficient evidence on record that should lead to a conclusion whether looting of Geneva, Switzerland, and looting of British Virgin Islands were two different and distinct companies. The court held that both companies were distinct, taking judicial notice of the fact that the Luton Investment Limited, referred to in this case, was a Swiss company based in Switzerland. That was the case of Nigerian National Petroleum Company versus Luton of 2002. So it's very wide in application. That's all we need to know. Moving on, courts also take judicial notice of the extent of territories comprised in the Commonwealth countries or in the Commonwealth. This section seeks to establish the jurisdiction of the Commonwealth countries and therefore requires courts to take judicial notice of the boundaries of states that fall within the Commonwealth. To this extent, a court has taken judicial notice without requiring proof that the Bristol Channel was not within jurisdiction when the Court of Appeal on these instructions of the Home Secretary held that a collision within the Channel, the Bristol Channel, had not occurred within the jurisdiction of the English High Court. That was in the case of Fairness, or I don't know how to pronounce this. Fairness, I don't know. 1927. Okay, moving on. The court also takes takes this fact and judicial notice of the fact that there is hostility between Kenya and another country, or the fact that the hostility has stopped or it's still ongoing. Okay, so courts are alive to the fact that a country may be at war with an enemy state, so that so far as cases before them are concerned, such is a fact that should be judicially noticed. Judicial notice has been taken of the continued existence of a state of war between England and Germany, where the applicant for a writ of habeas corpus was said to be still an enemy alien, unable to apply for the writ, notwithstanding the unconditional surrender of Germany. So that is in the case of R versus Portray ex parte, something Meister 1947. Yeah, so let's move on. The names of the members and officers of the court, their deputies, their assistants, and everyone else, the advocates, will be taken judicial notice of. Okay. Now, the underlying rationale here is that there are officers who are within the court's jurisdiction and knowledge, and it would be easy to identify them. To this extent, judicial notice has been taken of the fact that the Law Society of Kenya publishes annually a list of advocates who hold practicing certificates to inform the public, so that a memorandum of appeal signed and filed by an advocate who did not hold a current practicing certificate was incompetent. That is in the case of Obura versus Koome 2001 case. Now, judicial case has also been taken of the fact that documents drawn by an advocate who does not hold a current practicing certificate were null and void ab initio. The court finding as a fact that on the respective dates, two documents were drawn by an advocate who did not hold a current practicing certificate and was not therefore qualified to draw those documents in view of the provisions of Section 36 of the Advocates Act. Okay, I would like to point out a very important thing here. This was, I think, in the case of Ndolo, Wilson Ndolo Aya versus National Bank of Kenya. But this case was overruled by Anaj Warehousing versus National Bank of Kenya. So it stands to reason that right now the position is different. It's the opposite, that as long as it is an advocate and not a doctor or a fisherman who drew up those documents, then those documents are valid. Okay, and the question of execution of those documents by an advocate who doesn't hold a current practicing license, it becomes a matter of professional misconduct, as was the position held in Anaj Warehousing versus the National Bank of Kenya. Okay, so that's all you need to know. It was not updated in this book. Let me just note it. Anaj Warehousing versus National Bank of Kenya. Current jurisprudence. So an advocate is an advocate. And the documents are valid. Now, moving on. Courts also take judicial notice of the rules of the road on land or at sea or in the air. Okay. We said this, yeah? Like, keep left unless you're overtaking. things like that. So the rationale for this is that uniform rules should apply for every system of transport, because it would be unreasonable for the court to apply different criteria for every incident depending on its peculiar circumstances. To this extent, courts have taken judicial notice of the fact that a tram car, if driven at a reasonable speed but negligently failed to apply brakes, would collide with oncoming cars, and further that it carried passengers who paid fare separately. That was in the case of Chapman versus Kirk, 1948. Yeah. A court has also upheld the use of local road knowledge by a judge on hearing an appeal against conviction from a magistrate's court in the case of Chason versus Jordan of 1981. So, moving on, courts are inclined to accede to the fact that nature always takes its course and judicial notice should be taken of the ordinary course of nature. It has been held where a man was seeking divorce from his wife on grounds of adultery because she had given birth despite the fact that he had been abroad for 12 months. The court would take judicial notice that human gestation lasts 9 months, but it would not shut its eyes to the possibility of an abnormal gestation period of 12 months in the absence of proof of adultery. Okay, so here it's about whether it's okay. Now I'm connecting this to the previous video I made about presumptions, where the court will presume a child born in a marriage, in a valid marriage between two people, to be a legitimate child or son or daughter of the husband, okay? Unless the contrary can be proven. So it's a rebuttable presumption. Unless the husband can prove that there was no access during the natural conception time when the wife conceived the baby, or okay. So that is that. So you see here we have things that are connecting between presumptions and judicial notice, and it makes sense because both of these things, both the judicial notice and presumptions are facts or examples of facts which require no evidence. Okay, so that's why they are they are interlinked. So we see here also, as was the case in the presumption of legitimacy of the child, in under presumptions, it's the same case under judicial notice for the gestation period uh, of a human baby. Sorry, the gestation period, yes, that lasts 9 months, the natural one. But it's rebuttable because the husband was saying that he was away for 12 months, all right, for a whole year. But you see, the difference is only 3 months, so there can be an irregular. That's what the court is saying, if there's evidence to prove the contrary. Yeah. So, so the period of 9 months, gestation period of 9 months, can be taken judicial notice of, but it can be rebutted also. All right. It can be rebutted, like it was in this case of, which case was this? 61. The case of Preston Jones versus Preston Jones of 1951. It's an American case, I think. All right, so we move on. Okay, this other example is making me laugh. So it says in exceptional okay, ordinarily courts have taken judicial notice that boys are generally notorious in nature, and it would have been absurd to call evidence on that fact. That is a case of Clayton versus Hardwick Colliery Company Limited, 1915. In a divorce case where the issue was whether division of assets should be based on the respective contributions of the spouses. Okay. The court took judicial notice of the fact that in Kenyan society, it is wives who ordinarily shoulder the burden of nursing children. That is 63. Okay, that is case of Miriti versus Kithia, 2004. Okay, Kenya law report. So where the plaintiff was beaten by a camel, so it's here in this case of Miriti versus Kithia, it was the court took judicial notice of the fact that mothers are the caretakers of children. They raise them, they nurse them, they nurture them. Where the plaintiff was beaten by a camel, the question arising was whether a camel was a wild animal. Here we also discussed this before, whether the animals was wild or domestic. And the court took judicial notice of the fact that the animal was domestic. The camel was is a domestic animal. This was the case of Makweka versus Goddard, 1940. Now, where a charge okay, what is this? Where a charge preferred against 3 boys was for malicious damage to property by killing animals ordinarily kept for domestic purposes. The question arising was whether it was necessary to prove that the said animals were so kept. The court took judicial notice of the fact that cats are ordinarily kept for domestic purposes, and evidence of ownership was not necessary for conviction. That was in the case of Nye versus Niblet, 1918. So it also took judicial notice of the fact that cats are domestic animals. So we have many more examples. Okay, under this. This is the last one. Where a claimant's husband was killed in a motor accident. Home Office records disclosed that he had numerous criminal records and nothing to show that in his lifetime he had any honest employment and he possessed no assets. The claimant was aware that her family lived on the proceeds of crime. The court, in passing judgment, took judicial notice of the fact that the life of a criminal was an unhappy one, and therefore damages for loss of expectation of life, which in reality were damages for loss of the element of happiness in life, was assessed at 1/2 of the amount due. So, where in a civil suit you are asking for compensation for a life lost, and that person who died maybe in that accident was a criminal. So the court took judicial notice of the fact that a criminal's life is less worthy, in other words, compared to the life of a person who is law abiding. Yeah. So the compensation was less by half the amount that would normally be granted. Now, judicial notice has been taken of the number of illiterate persons in Kenya, and that this fact should be borne in mind, okay, in an action for passing off. So, that is 67. Brook Bond Kenya Limited versus Chai Limited, 1971. So, where the court took judicial notice of the fact that illiteracy in Kenya is hard. I don't know. I doubt, because many people go to school these days, but I don't know. So we move on. Courts are taken to have proficient knowledge of the English language generally and the meaning of English words. So this is another instance under section 60 where I said briefly that water means water. It shouldn't mean something else. It shouldn't mean a bed or a chair or biscuits, So in particular, which lends credence to the statutory requirement that they should be judicially noticed. Now, the rationale for this is that litigation frequently involves interpretation of language, so that a judge frequently has to decide whether a word in a statute or legal instrument is used in its ordinary meaning. All right. Clarification under the circumstances is sought from a dictionary, usually the Oxford English Dictionary, which is treated as an authoritative source. In a case where we have an example, in a case where a statute governing tenancies contain two prohibitions, one wide and the other applied to limited classes of cases, the judge held without calling evidence that the wide prohibition was to be treated as not applying to cases within the limited prohibition. That was in the case of Cannon Street Limited versus Singer and Friedlander Limited, 1974. England report. In a case, okay, this is what we say. In another case involving meaning to be attached to English words an applicant sought orders of revocation or annulment of grant on grounds that it was obtained fraudulently by making a false statement or by concealment from the court of material facts. To revoke the application was held to be bad in law because it did not disclose any reasonable cause of action, as one could move to court only to revoke, grant, or annul, and the applicant's prayer did not disclose any of these and was therefore defective. That was in the case of Julius Kithiki Moema versus Priscilla Ndomi Moema, 2004 Kenya Law Reports. Yeah. So, in South Africa, it was held that courts should take judicial notice of the fact that male rape exists, and the definition of rape should be extended to gender-neutral terms by adding the anal penetration of a male to the actus reus of the offense. Okay, that was in the case of Masia versus Department of Public Prosecutions or Director of Public Prosecutions, Pretoria, and others. So another example was the meaning of terminology was in issue where a court observed that although there was no definition of what market value as used in statute in common parlance, it connotes the price which an item ought reasonably to be expected to fetch in a sale on the open market. That is between a willing seller and a willing buyer when the market is legal, free, formal, and above board. So here they wanted to know the interpretation of what market value means. I think in Kenya we have an interpretation act. I can't remember how it is, what it was called. Let me just check. Yeah, the Interpretation and General Provisions Act of 1956. So this is in reference to legislation, okay? Terms that were used in the acts or statutes. Also, there are these rules of interpretation. We have the rules of, let me just check. There are so many rules. What were they called? We have so many, like a wide interpretation, a narrow interpretation, the literal interpretation of a word. Rules of interpretation. This is of statutes of legislation. Yeah, so this is statutory interpretation. We have the literal rule where a word is interpreted to mean in literal meaning of the word. The golden rule, the mischief rule, and the purposive approach. So those are the ones. But I don't think this section 60 is talking about statutory interpretation. I think it's talking about general interpretation of English words in the English language. All right. Okay. So we move to the next instance, which is the all matter of general or local knowledge may be said to be facts which are beyond serious doubt, are so well known or so notorious or of common knowledge. So facts of common knowledge which are well known and they require no proof, okay? Under early common law, a fact could be judicially noticed as a notorious fact if it was within the common knowledge of all persons of ordinary understanding and intelligence. So facts which are under common knowledge. Wow, now this has a lot, the longest explanation, which we will look at. Maybe we'll learn something here. So we have, it explains court should be alive to happenings in society, because this is what I say, the court cannot be disconnected, like a disconnected entity or robot that exists outside the society. It operates within the society, is up to date with the current knowledge, the general knowledge, okay, in the world, and what is common knowledge. The court should be alive to that. So that is what it's saying. So it's the general knowledge of, or the general usage in a society. Those facts must be so well known, okay, that there should be no disputes. All right. And also those facts, at least this rule understands that nothing is permanent and things keep on changing. So those facts can change also, so that what was known last 10 years about something is no longer the thing now, okay? Like for example, in Kenya, we all know that customary law, common law was of England is what is customary, but we saw that with the SMOTNO case, it was held that customary law in Kenya, or the common law of Kenya, is the customary law. It's not the common law of England. So things keep on changing. Now there's an example here. In the US, courts have long taken judicial notice of various scientific principles. For example, blood, radar, and breath tests for intoxication, fingerprinting, and ballistics. This was Okay, this policy is an enormous time-saving tool because it relieves courts from the necessity of taking lengthy testimony on basic scientific principles upon which common tests are routinely performed. So it's the American courts take judicial notice on breath tests for testing the alcohol level in the blood, and fingerprinting and ballistics reports, okay, for guns and bullets. So, on the other hand, a judge may not take judicial notice of adjudicative facts and are open to reasonable dispute, even if even if the judge is personally convinced of the correctness of a particular conclusion. So there's that element of discretion as well. So this was in the case of Hardy versus Jones Manville Sales Corporation, where it was stated advising that court should not take judicial notice that asbestos causes cancer with regard to an asbestos-related product liability action, because that proposition was inextricably linked to a host of disputed issues. Yeah, so anything medical, anything that requires expert testimony, the courts are cautioned against taking those matters on judicial notice, because we discussed this. I think we're just repeating this. So So courts in England have had to make a decision whether they can take judicial notice of the fact of rise in prices of land between 1954 and 1961 without there being any formal evidence on record in that behalf. Certain decisions of different courts were cited in this connection. For example, the case of Bryant versus Foote, it was observed that the true principle of the law applicable to this question is that where a fee has been received for a great length of time, the right to which could have had a legal origin, it may and ought to be assumed that it was received as of right during the whole period of legal memory. That is from Richard I to the present time, unless the contrary is proved. In this case, the right to these fees may have had a legal origin before the time of memory, and the evidence that they have been taken in modern times during a period of nearly 50 years leads to the presumption that they were lawfully taken in the time of Richard I, unless the payment at that time be disproved. That we are of the opinion that, considering the difference in the value of money in 1189 and the present time of which the court will take judicial notice, it is impossible that a payment of such an amount upon every marriage in this parish can have been made at that period, that the objection of frankness therefore applies that the claim is negatived, and that the plaintiff who seeks to recover back this fee which he has paid is entitled to the judgment which he has obtained. So that's a long explanation. So in this decision, the court took judicial notice of the fact that there has been a difference in the value of money from the year 1189 to the year 1866. Yeah, so it makes sense. Of course, money keeps on becoming, losing value. So whatever somebody paid to a property, for example, back in 2007, is not gonna be the same now. It's gonna be higher now. So if somebody is to be compensated, they'll have to pay more. Okay. In the case of Dennis versus A.J. White and Company, 1916, a workman who, in course of his employment, was required to ride a bicycle belonging to his employer through the streets of London, on average once a day, was knocked down and injured by a motor car in course of one of his trips. In an appeal on the question of compensation, which was awarded by the judge, Westminster County Court, sitting as an arbitrator under the Workmen's Compensation Act, 1906, said the following: the test which is always applied is the test that was laid down by Collins in Andrews versus Failsworth Industrial Society of 1904, as to whether there is in particular vocation some risk appreciably and substantially beyond the ordinary normal risk which ordinary people run. I have to ask myself whether, having regard to the known conditions of traffic in London with large numbers of motor cars and motor buses about the streets, a matter of which the court can of course take judicial notice, there was any appreciable extra danger incurred by this boy when he was sent on a bicycle through the streets of London once a day on an average. In my opinion, that question must be answered in the affirmative. Assuming for the moment, as I do, that the question can be dealt with and by this court and is not one for the Lanark County Court judge, a matter I will deal with later. So, an English court here took judicial notice of a crowded condition of London streets, that yes, the risk was high for the boy to be sent on a bicycle by his employer once a day, every day. So I think he was entitled to compensation. We have another case here. So it was a matter of general knowledge that London streets are crowded. So the commentators of, and this is another case of Phipson on evidence. Sorry, it's not a case, it's a book. 11th edition, okay, have dealt with various facts which the court can judicially take notice of as notorious. According to this book, the court will take judicial notice of facts which are notorious, the ordinary course of nature, the standards of weight and measure, kilograms, grams, the public coin and currency, and its difference of value in early and modern times, the meaning of common words and phrases, of nominal rent in a modern statute, or that beans are species of pearls, the existence of the universities of Oxford and Cambridge, and the fact that they are national institutions for the advancement of learning and religion, the difference of time in places east and west of Greenwich, the almanac annexed to the Common Proper Book, as being the law of the land, a number of days in a given month, or that a certain day of a month was a Sunday. Okay, so all these things in this book, Phipson on Evidence, it was explaining that the instances or facts which a court can take judicial notice of, common knowledge things that are naturally known to be true, okay, of a place, of a thing, or something, of a person. Now, the courts have also found that the streets of London are crowded and dangerous. And that boys are naturally reckless and mischievous as compared to girls. That cats are kept for domestic purposes. That people who go to hotels do not like having their nights disturbed. That's true. That venereal disease may lie dormant for a long time. That gestation is normally a certain period, that television was a common feature of domestic life and is used for entertainment. So all these things are examples of common knowledge, things that courts normally take judicial notice of. In a claim arising out of a breach of covenant, these are more examples. A breach of covenant to plant coffee, the defendant pleaded that it was washed away by strong rainfall and asked the court to take judicial notice of the normal intensity of rainfall and that erosion caused by heavy rainfall, okay, the court was prepared to take such judicial notice but was unwilling to agree without evidence that the rainfall in question was an act of God and that no precautions which the defendant had taken would have prevented washing away of coffee trees. So we see that there are so many instances that the courts can take judicial notice of a matter or a fact without requiring evidence. So another example is judicial notice has been taken in Kenya of the fact that the Seventh-day Adventist Church is an organization that can only make decisions through its organs, and delay in making such decisions would be inevitable. Okay. That was the case of Seventh-day Adventist Church East Africa versus MS Masosa Construction Company Limited. Courts have also taken judicial notice of the fact that in most robbery with violence cases involving more than one suspect, not all suspects attack and steal from their victims. Some are assigned other roles and are not directly involved in the actual robbery. So that was the case of Michael Mbugua versus Republic 2000 Kenya law reports. In a case where usage of the word market value was an issue, the court held it to be a matter of common notoriety, which it could take judicial notice of. This was a repetition, I think, in the case of English words, the meaning of English language. Excuse me. So where the issue was whether payment of dowry operated to validate marriage, and TESO customary law and practices, the court held that the issue of dowry was so notorious that the High Court and Court of Appeal are entitled to take judicial notice of it under customary laws of all African communities in Kenya, and that no valid marriage could be contracted without payment of marriage consideration or bride price. And that was the case of Atemo versus Omojaru, 2003. Gazette versus Gazette. Courts have also taken judicial notice not only of the existence of Kikuyu customary law, but also of the existence of other African laws, customary laws in Kenya. That was Gazette versus Gazette, 2001 Kenya Law Report. Judicial notice has also been taken of the fact that during the period of emergency in Kenya, many families in Kenya, especially in Central Province, were detained or fled their homes, and when the process of land demarcation registration started, those sons who remained behind were registered to hold the land in trust for those who were absent in the process, creating customary trust in land. Yeah, so, sorry. I thought I had something. So that was the case of Mbogo versus Mbogo, 2008, about holding land, customary holding land in trust. Okay. On an application to file appeal out of time, the court took judicial notice of the fact that the times between December 2007 and 5th February 2008 general elections were held, and chaos, there was post-election violence, so chaos ensued, thereafter disrupting normal transport and communication. So the appeal was allowed, 87 now. Case of Basho, Isaac, Dakat versus Republic 2008. And in another example where the issue was of ownership of a mobile phone, it was held that the method of determining the serial number of a cell phone or mobile phone is not something which a court can take judicial notice of, as it is not listed under Section 60. Neither is it a matter of general or local knowledge. So, common knowledge. So, a serial number. Who knows the serial number of a mobile phone? They are all different, and I think different models and all those things. Yeah, it doesn't make sense. So courts have also taken judicial notice of the following fact: that on August 7th, 1998, the American embassy in Nairobi was bombed and damaged, that an adjacent building that is of when the cooperative building was flattened, that the cooperative house next door had its glass windows shattered, that many innocent Kenyans died and other maimed for life, that on or about 28 November, Paradise Hotel at Kikambala near Mombasa was bombed and flattened, that the media reported that about 15 people died and 80 others injured. So all these things in the news, major events, all these things I find are interconnected. Customary laws, principles, written or unwritten. So it all comes in historical events, in the news, Okay. So, yeah. So now, okay, so we have finished the instances. So a final note is that courts will take judicial notice also of all other matters of which it is directed by any statute or act to take judicial notice. This is where statutory interpretation comes, because for example, mostly is about interpretation, where the Constitution of Kenya says land is defined to mean this, this, this. Okay, so that is the courts will take judicial notice of that, the meaning of land. So normally when it comes to statutory interpretation, I told you clearly there's an act in Kenya, the statutory Interpretations and General Provisions Act, and where this act defines who a person is, that is the meaning the court will take judicial notice of. If a person includes a company or association or body of persons or a corporation, then the court will take judicial notice of the fact that a company is a person, okay? Section 119, Presumption or Judicial Notice. So this is like, I told you, presumptions and judicial notice. Where is the distinction? Where do courts presume and where do they take judicial notice of facts? This is the final point to note. And here, Section 119 of the Evidence Act, so it enables courts to take judicial notice of any fact which it thinks likely to have happened, okay, of natural events, human conduct, public-private business. Okay, so this section gives ample authority to the court to take judicial notice of facts regarding her to common cause of nature, events, human conduct, public, private business, okay. The power to take judicial notice of facts in accordance with this section can be curtailed only by express provision of law and not otherwise. Section 60 of Evidence Act is about matters and facts which the courts can take judicial notice of. That is all you need to know. So the thing is that under Section 60 of the Evidence Act, it is mandatory for the courts to take judicial notice of those matters we have mentioned. But it doesn't mean that whatever wasn't covered under Section 60, which we haven't mentioned here in this video or in our discussions, cannot fall under that. No, there are so many, the list is not exhaustive. Okay, so I haven't gotten the distinction or the point that the author is trying to bring forward. But I believe that it's trying to say that Judicial notice and presumptions are closely interlinked because they are both falling under facts which are uh, uh, admissible or admitted without evidence, okay, admitted to be true by the court. And we saw things like under presumption of legitimacy of a child, that a child born in a valid marriage between two people is deemed to be legitimate unless proven otherwise. We saw that it was closely linked to the gestation period of 9 months, which courts have taken judicial notice of. So it's very closely interlinked. The difference is that a presumption, I think the difference could be that a presumption is taken, a judicial notice is by way of a person. A person can move to the court to take judicial notice, or it can be discretionary upon the court. I don't remember if in presumption it was the same, right? I down. Okay, I think that's it. We have concluded our topic on judicial notice. I hope you will remember the sections, appropriate sections 59 and 60 of the Evidence Act, and that section 60 is not exhaustive. There can be many situations about people and places that the court can take judicial notice of. We saw even about crowded streets of London streets. We saw so many things here. So it's good to keep in mind. Okay, have a nice day. Bye. Thank you. Enjoy your holiday.